All right, I want to pull back out to another issue that's in the news now. The Trump administration actively debating what to do with Venezuela. And obviously, we've seen these drone strikes. I asked Alan Dershowitz about this several times, and his answer was preventative, like taking preventative strikes against a threat to the United States is clearly within the president's authority. But here's the question that's now posed to Congress, which is, what if he goes onto the mainland of Venezuela? Does he need an act of Congress to do that?
I don't think so. Not under the way that the current law has looked at this, and not, there's been strikes all over the country. And I think what President Trump is saying is, I'm going to designate these guys as a foreign terrorist organization and go after them on that basis. Basically David Barron, the judge in the First Circuit, who's a liberal hawk, as liberal as could be, was the guy who authorized the strikes on al-Awlaki in Yemen. I think that basically this would fit into the general idea of war powers. I think the real thing that's triumphed here is John Yu's theory about what Congress's role. Congress has the right to declare war or not to declare war, but the president is the commander in chief of the military. And so there's a lot of things the president will be able to do more broadly if a war is declared, but the idea that the president couldn't take action in Venezuela on his own initiative, I think, is wrong.
Yeah, the House Democrats are trying to stage a vote on this, but it's interesting. Your colleague at the Article 3 Project, Mike Davis, tweeted, Obama ordered extrajudicial drone strikes on American citizens, including a minor. Now Democrats suddenly care about Emma Bove, a top drug, and so it's funny how suddenly they didn't care about when Obama used drone strikes to actually go after American citizens, and now suddenly they care about preventing drugs coming into the country from Venezuela.
Yeah, I don't get the difference here. The idea that, drugs are killers. These people are going to bring in drugs that kill hundreds of American citizens. We're not obligated to let them do that. If they're in the United States, then we need to operate within the normal purview of American law, but they're not. They're in international waters trying to invade our territory illegally. So no, I don't think they have any right to do that. And the idea that these are fishermen is totally fake. Once you actually read about the type of boats that are being used here and what they have on them, these are boats with 4 or 5 motors in the back. They are go fast. They are small, extremely fast boats designed to try and avoid interdiction. Normal fishermen don't have boats like this. So whenever you see one of these boats, these long, skinny boats with a huge number of outboard motors on the back, you're dealing with a drug boat every time.
So when the president talks about going into Mexico to do the same, is this, are we getting into, as long as it's isolated, he goes after a cartel or a drug smuggler, he's fine? Is that sort of an accurate read?
I think he would be fine legally. There are bigger problems when it comes to Mexico, because obviously Mexico is our southern neighbor, and we have very, very serious, intense trade relationships with Mexico, and we're relying on cooperation with the Mexican government to stop migration, to stop drugs crossing. So, we have to be thoughtful about how willing we are to violate their sovereignty without their permission. So Mexico's a much trickier case, and that's the kind of thing that doesn't apply when it's just drug runners in international waters. We're not violating the sovereignty of the Venezuelan government when we kill drug dealers in the middle of the Gulf of America. I'm sorry.
Good correction there. Will, I want to focus a little on the Supreme Court. There's a case before the Supreme Court about whether or not states can count ballots after they arrive after Election Day. It says the Supreme Court has agreed to decide whether federal law prohibits states from counting ballots that arrive after Election Day. This is a case that the RNC brought, and it says President Trump has long rallied against mail-in votes and has argued that allowing ballots to be counted after Election Day creates opportunities for fraud. He's claimed that the practice undermines voter confidence by making it impossible to announce the final results. Whether or not the results are announced at a particular time or not, what's the issue that the court's looking at here?
Well, the court is looking at, I think it's either in the Constitution or in statute, but there's actually a term that says, I think it's in the Constitution, there shall be an election day. And the question is not, does the fact that there's this mandate to have a day for the election, not a week or a month, mean that the votes need to be counted by that day? And so that's the sort of textual argument that's the center of the dispute. I think that the mail-in people and people who want to count ballots say you should take an expansive view of that concept. But the Republicans would say, actually, no, election day means election day, not election week. I think they have the better of the argument. I think that's why the Supreme Court granted certiorari. And I think it would be a huge win for the country. The entire point of an election is to resolve our disputes in a way that everybody is that doesn't just have integrity, but is seen by everyone to have integrity. And it's really obvious. And, people always poo-poo this stuff like conspiracy theories. You don't have to go back far in American history to see just how election fraud works. Go back to, Robert Caro wrote an entire book about the 1948 Senate election in Texas, where Lyndon Johnson beat his opponent and, through what Caro established pretty clearly was in overwhelming voting fraud, which was common in Texas apparently at the time, but that's how Lyndon Johnson won his Senate seat in 1948. So you don't have to go too far back in history.
So let's just play this out for a second. Let's say that the court says, you know what, according to the Constitution, it says an election day. Would that just wipe out mail-in voting?
No, but it would mean that mail-in voting ballots have to be received by election day. And it would be very, very good for election integrity, because it would mean that there's no realistic possibility of people stuffing the post offices with ballots after they understand what the result is and figure out how many votes they need to win.
So it's not necessarily a day, but it's saying that that's the final day of voting.
Right. Yeah. Like you could theoretically, you don't have to get rid of mail-in voting if you have election day, but it does mean that, when on the day that you've said everybody votes on this day, that needs to be the day that all the votes are counted and the result is, and there aren't ballots accepted after that.
All right, guys, fall's upon us. That means if you want to have a luxurious night's sleep, do what I do. Switch your sheets over to Boll & Branch. It's like staying in the nicest hotel you've ever stayed in your life. I feel like I close my eyes. I'm like, am I in the really nice hotel I stayed in once? But you can do that at home every night. Here's the kicker. To get Boll & Branch sheets, you have to use my URL, Boll & Branch, BOLL branch.com/Spicer. You got to use it exactly like that. Bollandbranch.com/Spicer for 25% off and unlock free shipping on your first order. Some exclusions apply. Well, the other case, one of the other big cases the court is looking at is this issue of the Voting Rights Act. And this has been fascinating to me because, it's funny how when they created these majority minority districts, that's not what the court ordered. It just sort of, and as long as Democrats benefit from this, they've been okay with it. But at the end of the day, if the court looks and says the Voting Rights Act is not applicable anymore because of where we've come as a country, what does that mean going forward?
Well, it just means you wouldn't have these sort of majority minority districts that are kind of saving blue seats in very deep red states. I think Alabama has 2 Democratic representatives out of 6 or 7, something like that. That's, if you understand Alabama's demographics and Alabama's voting trends, that's crazy. Alabama is a R+20 state. There's no reason they should have 2 Democratic districts when Massachusetts would be the similar example, roughly the same size, I think. And Massachusetts has 0 Democratic, 0 Republican seats. Yeah. And 0. So I don't think there's a single Republican serving in Congress in all of New England.
But as long as, so the issue is a race issue, not a politics issue. Right.
Well, the issue, the VRA issue, provisions at issue are essentially require the creation of these majority minority districts to ensure it's not a Republican Democrat thing. It's a black white thing. They need to make sure that essentially that black people have black representation is the theory. But I think the Supreme Court's going to look at that and be like, that's a violation of equal protection. You can't intentionally be discriminating on the basis of race in that matter. That's a violation of the 14th Amendment. So that can't be a basis on which to gerrymander congressional districts.
And if that happens, once that does, I would assume that all the states that have these, Louisiana, Alabama, et cetera, they immediately redistrict.
Yeah, they have to. Actually, they would be obligated to, because what we're
really
saying is that they're because it would mean that their original districts they're engaged in racial gerrymandering, which itself is a violation of the Constitution.
So when this happens, the Democrats can't claim Republican. It would be a court-ordered thing.
Yeah, they'd have to redistrict. Yeah.
Oh, wait, that's going to be fabulous. I mean, I assume, basically reading the tea leaves, that's where this thing is headed. Yes, I think so too. Okay. I asked Alan Dershowitz the other case that I sort of find fascinating is this issue about tariffs. And it's interesting. I want you to weigh in on this because, like I said, I have no legal training, experience, education, nada. And the way I look at this is that trade is constitutionally a congressional, legislative Article 1 function. And when the president went out and did what he did, with using the emergency powers. It was taking power that Congress had given him and trying to utilize it. The court, at least the way I heard them in the arguments, saying, I don't know, if we give you this, how would you ever be able to give it back to the Article 1 branch? And so at least the tea leaves that I read seem to indicate that the court is going to say, it's one thing for the president to have executive emergency powers, but these powers are inherently a congressional power that you can't just usurp.
Yeah, so there's kind of two separate questions that the court is trying to grapple with on the tariff case, right? The first question is, what did the statute enacted by Congress, the emergency power statute, grant President Trump the authority? Did he use his statutorily granted authority? And it seems like the answer to that question is yes, because the grant from Congress in that Emergency Act is extremely broad and basically gives the president to set all kinds of tariffs. And then the second question is, constitutionally, is Congress able to delegate that much power to the president in a statute, or do they, given that the power of tariffs was supposed to be reserved to Congress? Now, that sort of argument, that's a much more traditionally conservative argument, an argument that Republicans make against Democrats, the idea that Congress isn't allowed to pass these extremely vague, broad statutes granting authority to the executive, broad discretion to the executive branch over an area that Congress is supposed to run things. So, and it's weird, the Supreme Court justice actually mocked, I think, Neil Katyal, my old professor, for saying, I didn't realize you were going to be the champion of what's called the non-delegation doctrine, which is this theory that Congress isn't allowed to do such broad grants of power to the executive. I think that the administration is going to prevail here, and that the president's going to get the tariffs. And also, yeah, I think also there's another problem, which is, if you agree that this is wrong, you have to figure out the remedy. And so does that mean that President Trump has to give all the tariffs back? And how would you do that? I mean, tens of billions of dollars have been collected in terms of tariff revenue every month. So that would create all this sort of chaos in the market in terms of figuring out where that money would go.
But answer me this question, because we have done it in the past. There have been refunds of tariffs. If the court says, just like play this out for a second, if the court says, we don't think you had that power, right? How does it then turn around and say, but then you can keep the money?
Yeah, that's exactly the problem that I think of the Supreme Court justices are struggling with. I'm not sure how they're going to do it. That's another reason I think they'll ultimately side with ratifying what the administration has done.
All right. The last thing I really want to get into on this is where we are on immigration. Presidents deployed the National Guard to a bunch of places. A Tennessee judge blocked Trump's use of the National Guard in Memphis, but gives time for the government appeal. Where are we? Are we hear of the president deploying the National Guard to Charlotte? There's potentially a bunch of other cities that he's going to deploy it to. There's talk of New Orleans, et cetera. Are there when the court rules, is it in each specific case they're doing stuff, or is what they're doing then having broad effects on the other cities where he's deployed the National Guard?
Generally speaking, no, it's not having broader effects, because what's happening is that they're making it's district judges making specific orders about the use of the National Guard in the cities and their jurisdictions. So they're not precedent setting opinions. There's been a precedent setting opinion in Chicago in the Seventh Circuit, but that is on appeal, I think, to the Supreme Court already. There was almost going to be a precedent setting opinion in the Ninth Circuit, but then essentially Judge Immergut changed the facts around, because she's the judge who first put a temporary restraining order preventing these people from coming in. And she's now already held the mini trial and issued a permanent injunction. So that itself is going to have to go through the set of appeals. President Trump had won in the Ninth Circuit a stay of the temporary restraining order, but now that there's a permanent injunction, the whole process has to start over again. I think, again, President Trump will ultimately prevail here. The idea that there is an executive authority to use federal personnel to protect to use the National Guard to protect federal personnel in federal facilities is ridiculous. It's not just the statutory authority he has under the statute he invoked, Section 12406. I forget exactly what the broader part of the code is, but 12406. He also has the Insurrection Act if he needs to invoke it. And he has implicit and executive authority. This is something that hasn't really been talked about, but it's just something that's been discussed as a core Article 2 authority, is the right to just use federal personnel to protect your buildings from being attacked. It's just kind of obvious when you think about it, that the idea that local jurisdictions could defeat federal law enforcement by allowing people to riot, refusing to do anything about it, and then suing if he tries to bring in federal troops to block it, that inverts the supremacy clause. The federal government is supreme over the states. So you shouldn't, the idea that the Supreme Court would stand for federal law enforcement being defeated by states in that matter is just it wouldn't happen.
Yeah, there's a U.S. judge that upheld New York law barring immigration agents from courthouses. Like, I don't understand how a state can tell the federal government. It's called the supremacy clause, right? I mean, the federal government doesn't take its orders. So when these states say we're not going to allow you to defend federal property, federal agents, I just don't understand how that could possibly stand.
It can't. The answer is it can't. It can't possibly stand. To the extent district judges have ruled in a contrary fashion, they've been wrong, and they're going to get reversed by the Supreme Court. Like, I remember somebody, I think I was a journalist who asked me about this question, asked like, well, what do you think the administration's going to do if they lose? And I'm like, I don't think they've even reasonably considered the idea that they wouldn't win on this at the Supreme Court. And so, because she wanted to ask about defying court orders and, constitutional crisis, I'm like, it's just not going to happen. It's just not going to happen. They're going to, the administration is going to comply with these orders while they're enforced, but it's going to appeal them and win.
So last thing I want to ask you is, when we talk about the Supreme Court going to do X, right? So we've got this National Guard thing, the Lisa Cook thing. Those cases have been heard. Like, when could we expect a response on either or?
I mean, it depends on the specific cases. I think the most likely thing we're going to hear from the Supreme Court, I think we'll hear in pretty short order from the Supreme Court on both the Lisa Cook thing or I think we might have already heard from the Supreme Court on the stay. I have to remember that. And we might have lost on the stay there. I think we'll ultimately prevail on the ability to kick her out, but I think we lost on the stay. I think in Chicago and on the National Guard, we're going to hear pretty soon.
Really?
Mm-hmm.
So that's not, they one day, literally, we could just pop out and here it is. So it doesn't have to wait till the court, their term. Yeah. I mean, you could just literally.
Well, because all these things are on this temporary expedited basis, right? It's the Chicago ruling is a, temporary restraining order that was, the administration asked the Seventh Circuit to put a stay on that order. They declined that order. That can be appealed all the way to the Supreme Court, and you usually get a pretty quick response. And
the same thing with the tariffs?
Yeah, tariffs, I think you also will see something happen pretty quickly there.
Okay. Well, thank you for joining us, as always, breaking it all down and everything you guys do at the Article 3 Project. Really appreciate it.
Happy to do it anytime, Sean.
All right, take care.
Well, if you enjoyed this content, make sure to like this video, subscribe, and click the notification bell to get more.